Georgia Malone and Company. Counsel, you want any rebuttal time?
Yes, 2 minutes, Your Honor, please.
Okay, go ahead.
May it please the Court, my name is Jeffrey Metz of Adam Lightman Bailey, PC. I represent the appellant herein. Your Honor, here this afternoon seeking modification of the appellate division order and the reinstatement of the unjust enrichment complaint against what I will call the Jung rights defendants. Now, Your Honors, as this Court has said on several occasions, I think that the essential inquiry here is whether it is against equity and good conscience to allow the defendants to retain.
Well, talk about that. Why is it against equity and good conscience from your perspective?
Judge, my client did all the work here. My client, and we have it in our brief, did this extensive due diligence based on this confidentiality commission agreement that they had with Center Rock Realty. This was information that was necessary to determine whether due diligence should be given to purchase a parcel of 13.
They didn't ask you to do it, though, right?
No, they had nothing to do with that, but it's not necessary for them to do that.
And what did they do wrong?
I'll tell you exactly what they did wrong. They took the information that was sold to them by the readers, knowing that it was our information. They took that information, they used it to consummate the sale to Orbach Group, froze us out of that deal.
Why isn't that a tort? Why isn't that conversion or misappropriation or something like that?
Well, because I think this is a situation where equity clearly applies. Now,
well, no, I mean, as I understand, unjust enrichment doesn't kick in unless you, unless there's no, I'll rephrase it, you can't have an unjust enrichment claim where you've got a possible tort claim. They're different things. I mean, unjust enrichment isn't for catching up with wrongdoers, is it?
Well, sure it is, Judge. What it is to right a wrong. As you said in Mandarin.
Any time somebody's done a wrong, you can sue them for, and you want to right it, you can sue for unjust enrichment?
No.
Well, under Mandarin and Sperry, don't you have to show some kind of a relationship between the parties?
Exactly right.
And it can't be too attenuated, right?
Exactly right. And
so how do you meet that standard here?
Thank you for asking that question, Your Honor. Your Honor, if you take a look at the complaint and you look at paragraphs 85 to 92, as well as the Georgia Malone affidavit, which amplifies the pleading. Remember, this is a pleading case. You must accept all the allegations is true. What it says is what I was trying to indicate before. We prepare this due diligence information. This due diligence information is then sold by the readers in violation, well, Center Rock as well, but the readers.
Who paid for that, Center Rock?
Center Rock, well, Center Rock didn't pay anything for this. Jung Rice paid for it. That's what happened. Jung Rice purchased this information from the readers, took the information, used it to make the deal with the Orbachs, froze us out of the deal.
So what's your relationship to them?
I don't have a relationship to them. I don't need that. I don't need privity with them.
What do you need? What do you have?
What I need is an awareness. We needed an awareness and a not too attenuated standard. Now, they knew this was.
I guess my concern is you may have a very good unjust enrichment claim, but I'm trying to figure out who that claim is against under our existing case law.
I think everybody can agree here that what happened to my client is wrong. It was wrong what Center Rock did, it was wrong what the readers did, and we submit that it was also wrong what Jung Rice did. We, as the dissent said, they knew, based on the allegations in our complaint, they knew that it was our information. Remember, Your Honor, this is a pretty closed community here with these off-market transactions. There's not a whole lot of brokers involved, and this is a fairly large assemblage that was being sold here. Very substantial commission as well. If you take what you know to be stolen goods, essentially, and you retain those stolen goods, you use those stolen goods, you make a profit off those stolen goods, you kick back some of that money from those stolen goods, and you don't give anything to me, that's when unjust enrichment comes in. Now, this
what case says that?
What case says that?
Yeah.
Well, Your Honor, there's several cases from this Court.
One good one.
Well, I would say the Bracken case is the closest one on point here. The Bracken case cited in our brief from 1970, that was the case, Your Honor, where a broker was hired to get financing for this particular corporation. The deal was for you bring somebody in, and if there's subsequent financing that comes about as a result of that, they got a commission. Now, somebody from the corporation there found out that this particular entity was brought in. They then come in and they take the deal for themselves, essentially. And when the broker said, I want my commission, the fellow said, no good. And this court said, no, unjust enrichment comes into play here. Now, this is also, I mean, this is not Mandarin, for example, nor is it Sperry.
But let's talk about that. What about your relationship to them? Why is it not too attenuated?
It's not too attenuated because they knew, Your Honor.
Assuming you don't need at the behest. Put that aside.
Assuming
you don't need at your behest that they.
Okay. Well, okay.
Or their behest. Assume that's out of the. Why isn't your relationship too attenuated?
Because it's not too attenuated because they knew that the property that they had, this due diligence information that was put together by my client at considerable cost to it.
They knew it was you?
Yes.
Who did the work?
Yes.
How did they know the work?
Well,
from the stamps on the paper?
Well, they knew it from the stamps on the paper. I'm sorry. I mean, the link that's at page 439 of the record, it's now expired, but they had to do it through a link because the information was so substantial. But all the information had Georgia Malone and Company.
But is that the relationship that they know it's yours,
yes.
So therefore you have a relationship with them?
That's exactly right.
And that's why it's not too attenuated?
That is exactly right, Your Honor. But for our due diligence information that they took. Now, remember here, this deal fell apart. The seller was anxious to sell the property. The seller did not want to give another due diligence period. Orback Group didn't need another due diligence period because it already had the information that the Riede sold to Jung Rice and Jung Rice gave to them. That's how this deal got done 11 days after they received the information and at a substantial discount to the seller because instead of $70 million, it went to $68.5 million. So that's where the relationship is. When there is a debt to be repaid, this court has said that the law implies a promise in the absence of a contract. And that's just what this court
And you believe you fit in under our more recent cases?
Well, only to the extent that Mandarin says if you have an awareness and the relationship is not too attenuated.
You think you've made the awareness?
Yes, absolutely.
Yeah. What else does Mandarin say?
Well, Mandarin goes on to say, I mean, and this is, look.
Does talk about reliance and inducement.
Well, okay. Well, I think
that's slightly different than
reliance and inducement. I would suggest, as the dissent here did, Your Honor, that particular paragraph has to be looked in the context in which it was written and in the particular facts of that case. Remember, this court found here that there was that Wildenstein had no relationship with Mandarin. And Wildenstein got nothing out of the deal. Wildenstein did not profit in any way by writing this letter to this mysterious Remington, this third party, who then transmitted the letter to Mandarin. It didn't go from Wildenstein to Mandarin, so there was no relationship there. So I think what this court was saying, and you can certainly tell better than me, you said that without further allegations, under the facts alleged, this is talking about Mandarin, there are no indicia of an enrichment that was unjust when the pleading, enrichment that was unjust. There was no enrichment that was unjust. Wildenstein got nothing from writing the letter to the third party. And it goes on to say the pleadings failed to indicate a relationship between the parties that could have caused reliance or inducement. Continuing, this court continues. Without further allegations, the mere existence of a letter that happens to find a path to a prospective purchaser, here's the key language I would submit, does not render this transaction one of equitable injustice requiring a remedy to balance a wrong. There was no wrong committed in Mandarin, according to this court.
Okay, counsel. You got some rebuttal time? Let's hear from your adversary.
Good afternoon, Your Honor. Jeffrey Miller from Westerman Ball, Ederer, Miller, and Sharfstein.
Counsel, what could be more unjust than what happened here in terms of their work and the profit that you made out of their work, aware that it was their work?
Well, first of all, you have to really look at their complaint. right? A lot of the things that counsel was saying aren't in their complaint or even in the affidavit that was submitted. This is a motion to dismiss, and if you look at their complaint, which is on page, the relevant provisions on pages 264 and 265 of the record, what it really says is that they're a broker. They put together some materials.
Right.
They signed a contract with a buyer to try to sell that, because they were trying to sell the buyer the property. The buyer backed out of the deal. The buyer eventually gave the materials. Well, they have two different stories of how.
It's the due diligence materials that are at issue here, right?
That's what they say.
Not particularly the sale of the property.
Well, I don't know that that's true.
Well, it's the commission.
Their agreement that they signed with their buyer was an agreement that provides that they get a commission of 1.25% and that they're going to provide materials to their buyer.
And there was a confidentiality clause.
That's the only reason why the appellant can say it's confidential. I mean, in the real world, this type of stuff is not confidential. I mean, it's a factual issue that.
Yeah, but what does your client do that isn't against equity and good conscience, in the words of Mandarin?
You know, Judge, I think counsel said something in his presentation which is really dispositive.
No, but what's the answer to that?
I'm going to say, he said, I don't have a relationship with Young Rice. Here, you know, it's always been the law, and it's always been, I believe, the correct law, that when someone.
But weren't you aware that these materials were confidential, and weren't you aware that it was their work product?
Okay, that's a key point that you just made.
Yeah.
There's no allegation in the complaint that my client was aware that this material was confidential.
Would you not be aware, given that it was stamped all over these materials?
That's not anywhere in the record either, that it's stamped all over the place.
If that allegation were added, would this be a good unjust enrichment claim?
No, I think if the material was truly confidential, they would sue for a misappropriation claim, Your Honor. They would, which is along the lines that you were asking before. They would say that you, through improper means, you bought it. By the way, my client didn't buy this material.
You're saying either you stole something or you didn't, and if I did, just sue me for stealing?
That's right. That's right, because it's always been it's never been the law that just because you receive something, that even if it has someone else's name on it and you have a benefit, that you have to pay them if you get the benefit. And it can't just be that you're aware of that person and the person's a stranger. The key distinction, it seems to me, the key distinction is you can't just be aware of the plaintiff. You have to be aware that they're conferring a benefit upon you. It just can't be that you're aware that there is somebody out there.
So are you saying this is improperly pleaded?
I'm saying this particular claim for unjust enrichment doesn't lie.
Because if they did the work, and the work was supposed to be confidential, their deal fell through, and you knew that this is confidential information that belonged to them, and their deal fell through, but I'm going to take it for my own use, and then
and we obtained it through some improper means, which is the standard of misappropriation.
No, not through an improper means. I mean, you just used it, and I'm sure you can say, I didn't know, you know. But my point is that the benefit that you gained from this was the benefit of their work.
That's what they're claiming. Right. That's what they're claiming.
Isn't that unjust enrichment?
No. I think unjust enrichment is that you can't just receive a benefit from any stranger in the world. You have to be aware that that stranger is trying to confer, or that party is conferring something on you, or that they've induced you to use it, or that they know you're relying on what they're giving.
Well,
or else anytime, I'm sorry, just in case any piece of paper ends up in your hand, and you have a benefit in it, and it has their name on it, you're going to pay them for it. How could commerce work that way?
I agree, because it seems to me that if you've got this work product and the knowledge in the community, because this is a strange area of real estate and everything else, is that this is really valuable, and you get this and you say this is really valuable, and it belonged to them, their deal fell through, but we're going to take advantage of all their work, and then we can close this deal for less. And lucky us. And they're saying, well, the luck should be ours.
I would say a couple of things. I would say there's nothing in the record that this is a closed, that it really is I don't believe it's a closed community. Number one, there are tons of brokers in this city selling buildings all, in Manhattan all the time, right? Number one. Number two, this type of stuff isn't confidential. Information about property is not confidential, which is why they didn't sue for misappropriation of a trade secret, because I don't think that they believe their information is confidential. The only reason that they say it's confidential is because they're written agreement with their buyer, who chose not to buy the property, who's one of the other defendants in the case, and they have a claim against them.
So how did this wind up in your hands? How do you know this information?
They have two stories that they say.
How do you know?
Right. One is that it was given to us by a guy named Joe Eisenberg. That's what they pleaded in the complaint. And then in an affidavit on their motion to renew.
What are you alleging? How did you get the information?
Well, I could tell you how we got it, but that's not part of the record. If you'd like, I can.
Tell us what you contend, how you got the information.
We got it from their buyer. We didn't pay for it. The payment was for their buyer's due diligence materials, environmental reports, and all sorts of other things that their buyer actually had out-of-pocket costs of over $100,000. And when we got the materials, not just this, and this stuff's not confidential, it's common, it's just general information about buildings in the city. We said that if we sold the building, we would reimburse this guy for his out-of-pocket costs, having nothing to do with the plaintiff.
Okay, now that you've had, let me ask you a different question. For purpose of deciding this case, what do we have to assume about how you got the stuff?
You have to choose one of their two stories, either what they put in the complaint that a guy named Joe Eisenberg gave it to us, or that what they put in their motion to renew that their buyer gave it to us. You have to.
So on either of those theories, are you responsible in an unjust enrichment claim?
No, because again, Your Honor, we just ended up with something that they claim we confirmed that we received the benefit, but it wasn't at their insistence. They didn't rely on us. We literally, this is not hyperbole, have literally no relation to them. They've never talked. There's no communication.
Yeah, but you knew the information that you were using, you knew was there. So they're claiming you do, and you don't deny that.
But that's not.
But you don't deny that, right?
Well, anything.
You were aware that was their work. Their diligent work that you got a hold of. You knew that was their work. You were aware of that. Yes?
Anything they put in the complaint is deemed to be true. So they've said in the complaint that they prepared the materials and we got them. But we didn't know it was confidential. There's no allegation in the complaint. We didn't know they had an agreement with their buyer to keep it confidential. And I would just say, I would just make two.
But you were aware it wasn't your work, right?
Well, we were aware that it was theirs. That's correct. That's what they pleaded.
So why isn't that enough?
Because that's never been the law. That hasn't been the law in any of the departments. I don't think that's what Mandarin provided.
Mandarin talks about you being aware.
Mandarin, but I think the language that was used in Mandarin was that.
Wasn't Wildenstein different? Wasn't that a different situation? Can't you draw a distinction between the facts in this case, as they allege, and the facts in Mandarin?
I don't think so, Your Honor. I would suggest.
Why not?
I would suggest that the.
Did Wildenstein have the same awareness that you have? You're alleged to have had?
Well, that's true. That is a distinction between the two.
So isn't that a good distinction in that Mandarin talks about awareness? You had it, Wildenstein didn't.
I think that's a distinction, but it's not a legally significant distinction because I think
there certainly was a benefit that.
They've alleged there's a benefit,
able to take advantage of because you were able to close in 11 days. You didn't have to do a whole separate due diligence.
Well, that's not in the complaint. All of that's not in the complaint. That's just counsel's statements. But what I would say is it's not legally significant because the law, as it's been for the past several decades in every department, and I believe that Mandarin was just confirming that, is that it's not enough. The awareness standard is just highlighting and describing whether the relationship is too attenuated. You also must have. Well, it goes to the whole issue of good conscience and what's equity. I mean, doesn't it go to that issue if you're aware? Is that what Mandarin is really all about? Yeah, but Your Honor, it also has to be unjust. And the cases are clear.
I close with the same question I asked you to begin. What could be more unjust if what they say is true?
That it's something that came into our hands, and we had no relationship. There's no relationship between the parties that caused any reliance or inducement. I would just make two quick points.
Let me ask you a question. I can get over time. You can't.
Exactly.
Yeah, but isn't it? How important is it in your view that they have not? That this is not, or you claim it's not, and they don't say otherwise, a protectable trade secret. I mean, if there's a law of trade secrets and there's a limit on what can be protected, either this is a trade secret that you got or it isn't, right?
That's right. Either it is or it isn't. That's right.
I mean, I guess for you, this is a softball question. But is the problem here that they're essentially trying to effectively to expand trade secret liability by calling it unjust enrichment?
Yes, and expand unjust enrichment law. I mean, they have a contract. They have a remedy with the party they had a contract with. That also precludes a claim for unjust enrichment. There is a contract that covers this subject matter. Their contract with their buyer, the very purpose.
Not a contract with you.
No, but the law is clear, and it's always been clear that a non-signatory to a party can't be sued for unjust enrichment if there's a contract that covers the subject matter of the suit. They're suing, claiming that we used their materials and got a broker's commission. They signed a contract with their buyer to have a broker's commission and provided those materials. It's the same subject matter. They can try to call it separate transactions. They can define it any way they want. But there's only one set of buildings that was sold here and only one set of materials that's at issue.
Okay, counsel. Let's hear from you.
Thank you, Your Honor.
Rebuttal from your adversary.
Your Honor, just briefly starting with the last point first.
Yes, please.
That argument was never raised in the courts below. It should not even be entertained.
Which one? My trade secrets theory?
Well, Judge, the trade secrets theory, I must say, is a really fascinating thought that, frankly, I had not thought about. But I think what we're really dealing, and let's just get the terms defined a little better here. It's confidential information because the particular initial deal was done off-market. This was not something that was.
The simple question is, if they stole your information, why don't you sue them for stealing your information? Why do you have to call it unjust enrichment? That's a tort.
Well, Judge, maybe we can do that as well. But I do know that I still have.
We have said that unjust enrichment isn't just a catch-all you use every time you can't think of something else.
Well, I don't think it's something. I don't think it's something that you can't think of anything else. What you have here, and remember, what you have here is the retention of benefits, knowing that they were ours. And I'll just close on this, Your Honor.
Go ahead.
This is a pleading case. This is not a summary judgment case. This is a pleading case. Counsel has made several statements here that I certainly don't have the time to rebut. But, his clients have not been subject to discovery. The only statements that we have in the record are an affidavit from.
Counsel, why is it confidential to them? To them, why is it confidential?
It's not necessarily confidential to them, except for the fact that they took our goods. They took goods that were stolen from us and used these goods. If you don't want to call it confidential.
So you're really going on the theory of awareness that we talked about.
Absolutely, Judge. They were clearly.
You keep calling them goods, but you don't really claim to have a protectable property interest in it.
I had a protectable property interest with Centerock. I had them for breach of contract. That was never an issue, and that's not an issue before the court. The issue before the court is whether his clients can escape liability for taking goods that they knew that were stolen.
If this was a watch and it belonged to you and they took it, obviously you can sue them, and you wouldn't have to talk about unjust enrichment. You'd sue them in conversion.
That's
Why
correct.
is this different? It's not a watch. How is this different from a watch?
Well, it's different. It's different in as much as they took money that should have been ours. That created a debt. And the debt, under equitable principles that come from this Court, once a debt has been created, the law implies a promise, regardless of the intention of the party.
Metz, if it was a legal client and the client went someplace else and you had expended a great deal of money, in investigating and bringing the case to not quite to fruition, but you're, ready to, and they take it and they take advantage of all of the work of your investigators, your paralegals, et cetera, your claim would be that they owe you for that.
They would owe us under the contract we would get a commission if the sale went through.
Right.
That's what we had. But the agreement that was called confidential, the agreement said that information could not be disseminated without my client's permission, and clearly it was.
Okay,
Thank you, Your Honor.
Thank you both.